Sorry to interrupt you.
Not at all, thank you. I should try and get through it a little quickly now. If I may then please start where I left off, I hope. Page 121.
Yes.
The Employment Tribunal decision, paragraph 64.
Yeah.
And so we have above paragraph 64 the complaint, failure to progress, allegation against Mr. Laniardo, etc., which we've already explored in some detail.
Yeah.
And then paragraph 64 sets out the context. 66, respondent contends there's a distinction between the claimant and Mr. L. The Hollywood report found none of the allegations to be well-founded. Given the very different findings of the Hollywood report and Mr. Laniardo's insight, the Trust decided to continue working with him. This is very different from the claimant, where the relationship was brought to an end by a compromise agreement after litigation had been issued. Case examiners closed the case against Mr. Laniardo because the realistic prospect test had not been met. Pausing there, the tribunal have well in mind what the respondents say the position is. Haven't overlooked it. Very different, they say. Tribunal find at 67, tribunal is satisfied that there is a difference in the way the claimant was treated in contrast to Mr. Laniardo. The difference was because of the findings made by the Hollywood report in the case of Mr. Laniardo did not justify proceeding, including the AR allegations which weren't considered credible in his case. While there is a difference in the overall conclusions of the Hollywood report, in the claimant's case, the respondent presented a basis for continuing proceedings based on AR, a witness not considered credible in the case of Mr. L. So pausing there, they are focusing on the right issues. They're not taking this all in one lump. The particular incident of less favourable treatment here is the treatment of the row allegation. It's not, you treated me really badly through this process. This is, you did this to me in this respect. Tribunal consider that, take account of the respondent's case in relation to that, and come to a judgment that the circumstances are comparable. That's a judgment absent perversity in my submission.
Where's that judgment?
The tribunal is 67.
I see. I'm sorry. I thought you were coming somewhere further on.
No, sorry. They're making.
It's there. It's there.
They're making a judgment about the.
Yeah, I've got it.
Yeah. And then, please, turning to page 123, characterises a discrete complaint, but in essence the same thing. So just under
that's so, is it? That had puzzled me when I was working.
Well,
I couldn't really see what the difference was. What the emphasis is this not just a question of continuing and not continuing, part one, but also continuing in the face of an understanding that Mr. Rao was likely to be unreliable. Okay.
But there is obviously a plain overlap, and the evidence in support will be very clear, plainly. So, and if we can look that, please, then at yes, so that's yes, and then so paragraph 78 winds up that issue. Tribunal is satisfied that there was a difference in the way that the claimant was treated in contrast to Mr. L. That is, despite forming the view that A was unreliable and conveying that view to Mr. L when ceasing the investigation against him in 2016, proceeded with the allegation against A.R. in relation to the claimant. So, same point again. The next significant, well, indeed the final significant complaint is the issue of delay. And just introducing this firstly, if I may, in relation to delay, the tribunal adopted a different approach. So whereas in the earlier complaints, they had looked for a comparator and found one in Mr. Laniardo, in relation to delay, there was no comparator. So they did what the respondent in their submissions invited them to do, which was to do a shamoon, so to speak. So in the
respondent submissions, well, let me take you to them because it perhaps expresses it better than I can. So if we look at the respondent submissions in relation to Shamoon, promising I won't take you to it, if I can ask you please to look at the supplementary bundle at page 59.
Yep.
GMC invites the tribunal, page 59, para 41. I know this is all familiar with you, but I'd just like to set it into context. Tribunal to adopt the approach identified by Lord Nichols in Shamoon. Analysis seems to point to the conclusion that employment tribunals may sometimes be able to avoid arid and confusing disputes about the identification of the appropriate comparator by concentrating primarily on why the claimant was treated as she was. Was it on the prescribed ground, which is the foundation of the application? That will call for an examination of all the facts of the case, or was it for some other reason?
Yes, the thinking is, if an act was on the grounds of race, it will follow
Precisely.
that somebody who was not of that race would not have been treated in the same way. It's not actually quite as simple as that, but that's the broad
Precisely.
thinking. Yeah.
And then at paragraph 42, that was the approach urged upon the tribunal by the respondent. That approach is particularly appropriate in the present case, where the reason why the claimant was treated as he was is recorded in writing and contemporaneous documents drafted by multiple decision makers, and where the claimant relies on numerous examples of less favourable treatment. And we say the reason why the Shamoon approach was particularly apt for delay was because there was no actual comparator. The delay was extremely excessive. So rather than seeking to construct a comparator, then ask, was there a difference in treatment, one simply asks, why did this happen? And as my Lord Justice Underhill says, if one finds, well, it's happened because you're black, then one doesn't need to then construct a comparator, one has the answer.
Well, yes.
On what basis did the tribunal found, if they did, that the reason for the delay was that Mr. Karim is not white?
Yeah. Well, let me take you to the findings. That's probably the easiest way, rather than to try and summarise them and end up making more of a mess of them. So, first of all, they identify at paragraph 79 the extraordinary delay, setting out what the normal threshold is. So it's 3.5.
Is it extraordinary?
Well, it says.
I know it says what the target time is. Was there any evidence as to whether the target time is ever met?
Well, there was no evidence that it wasn't ever met. There was evidence that it sometimes wasn't met, so far as I recall. But where one is looking at, again, one can only go with the evidence one has. If there is a target time of X and there is nothing suggesting that there was some particular reason why that might be missed in this case, then absent something else, the tribunal is entitled to say, well, looking at the target time, this is extraordinary, unless there is something to, well, my lord, it's your lordship is not convinced.
You would surely need masses of statistical evidence as to the delays in various types of case, and whether it can, if you could show that the cohort of ethnic minority doctors being subjected to disciplinary proceedings were processed much more slowly than a comparative cohort of white doctors, that would be overwhelming evidence. But I don't follow why, if it is shown that a particular case has taken a very long time, that's prima facie evidence of discrimination. It may be prima facie evidence that the system is dysfunctional and slow. And
absolutely, and I'll come to why I say it's an important point. But as I remind your lordship, I said this morning, it would have been open to the respondent, if they thought this was the case, to say there were lots of mess ups, somebody was sick, whatever. that the fact is they relied on the evidence they relied upon. And in terms of
sorry, I'll let you finish.
your question, my lord, how do we know it's extraordinary? Well, what the tribunal have are the target times, and then they have the explanations from the respondents that they're entitled to consider at this stage on a Shamoon analysis, the explanations for the respondents saying, well, this is why it took so long. So the respondents rely on a series of matters. The tribunal carefully goes through them and says, well, no, that doesn't justify that period of time. That doesn't justify that period of time.
But suppose all that is right. Still, what is the reason to believe it's anything to do with the race of a particular complainant?
The tribunal has to make a judgment on the reasons given.
You can't just make a judgment out of... Suppose a lot of inadequate reasons are given. You can't just jump from that, even with the persistence of the burden of proof provisions, to an inference that it's due to race.
I absolutely accept that, my lord. What happens is there are these findings made under the issues part, goes through, says this is what's said to be the reason for the delay. We don't accept that for the following reasons, and they go through them all carefully. And then it comes to the conclusions part, and at the conclusions part, the tribunal then say, here we have what we found already, then we have stats, then we have equal opportunities, then we have persistence in, for example, in relation to Spire, and from all of those matters, we conclude that the burden has shifted. Well, my lord, one is tempted to wonder at whether or not the burden of proof shift has caused more problems for claimants than it's provided answers to, really. But that's the basis of it, and certainly so far as the authorities are concerned, as your lordships know, and as the EHRC is concerned in their code of practice, things like statistics and equal opportunities training and policies is material for the purposes of determining whether or not discrimination is more or less likely to have occurred, which is why they form the basis of some of my submissions. So when one's saying, here's what we've got by way of primary findings of fact, and when you add to that, these matters from which an adverse inference can be drawn, then we're in burden of proof shift territory.
Wait, perhaps you'll need to come back to that. But the point you're making structurally, which is a fair point and I take on board, is that the way the tribunal has structured it, we shouldn't look in the section from 79 to 85 for a finding that the burden of proof has shifted, still less that it hasn't been met, because that is all what they do at the end under the conclusion section.
Precisely.
Well, okay, well, you'll be taking us to that in due course, I suspect.
I will be. I'll have to spend a moment on that plainly. But just in relation to delay then, just to introduce it before I take you to the particular matters, at this stage, the tribunal are making primary findings of fact about what happened and why it is the respondents say it happened. And those are the facts. And if I can just, those are their findings of fact. And if I can just have a look then, please, at paragraph 80. So you'll see paragraph 80 respondent contends there were a number of reasons for the time taken in the claimant's case. So addressed the issue head on by the respondents, waited for the outcome of the trust investigation, trust informed the respondent of the outcome.
Well, again, if you're
why don't you...
Tell us how much you'd like us to read. And we have read the whole of this section, but what particular points you want us to read again?
Perhaps I'll deal with it then like this. Perhaps I'll just pluck out the points that they made, and then perhaps that's a more helpful way to deal with it. So at paragraph 80, there were a number of explanations put forward, or reasons for the delay, waiting for the trust, complex case linked to Mr. Motawala's, no desire to duplicate the interviewing of witnesses, there was an error at one point, and the number of allegations meant it took longer, and delays common, which was your point, my lord. There was some evidence that delays were common. As to 81, the tribunal's conclusions, however, that the apparent tenacity, which is a reference to Spire in my submission, in the investigation of peripheral complaints, I'll come back to Spire, takes account of that.
This is a little bit, if you're right about Spire, I mean, this is not terribly good drafting because this is a section specifically about delay.
It is, but what's being said...
How does this fit in under delay?
Well, what's being said is, rather than getting on with it and coming to a decision, inquiries are being made that are going nowhere, and they ought to know are going nowhere.
Precisely.
Well, they're two rather different things, aren't they? I mean, when you referred us to the findings about Spire, it seemed pretty close to a finding of bad faith that the GMC were scrabbling around to try to find something, however trivial or however long it took. And if that is what the tribunal found and gave reasons, then that's a pretty powerful finding of bad faith, but it hasn't got anything to do with delay.
Well, it's part and parcel of the delay. If the GMC are pursuing allegations that they ought to have known aren't going anywhere, then that is contributing to delay. It is taking longer because they are doing more work when actually they should just shut it down.
And to the tribunal make a finding, not simply that there was delay, but that there was deliberate delay motivated by bad faith?
Motivated by a desire to get something on the claimant, yes.
Yes, right. Well, where's that?
Well, they don't, those are my terms.
The apparent tenacity and investigation of its peripheral complaints.
Yes. So that's a matter they take into account. So they explore the reasons given for the time taken. They take account of the fact that there was very lengthy delay. In my submission there was. And there's lots of cross-examination on all of this. What we're doing is precisely why it's difficult to run these cases afresh at the appellate level, because we don't have the notes of evidence. We don't have your lordships and your ladyship hearing me cross-examine and hearing Mr. Hare cross-examine, and the tribunal sitting there thinking, not sure about that. That doesn't sound very
That's why we have a
convincing.
reasoned judgment to help us.
We have a reasoned judgment, but a reasoned judgment to help the parties.
Well, hang on, you kept saying that. It is also one of the reasons the cases say about reading is not just to help the parties, but also to enable the validity of the reasoning and the cogency of the reasoning to be assessed on appeal. I can't remember, but I think all those cases, English and Emery Reinhold, mentioned that as an important reason.
But the focus is on telling the parties why they've won, bearing in mind that they know what the submissions were made and how the cases were put. Certainly, that's said in certainly one of the cases which...
That's said in lots of cases, but my point is it's not the only reason.
No, it's not the only reason.
Not even the main reason. There's a series of important reasons for giving reasons. The third one is, for the tribunal's own benefit, to make sure they think clearly.
Yeah.
Ask themselves the right questions.
My lord, I make the point simply that the parties here know what happened, know the submissions, and this tribunal, this court, doesn't have the benefit of hearing that, hearing the cross-examination, seeing all the documents, and when one's looking at, is this good enough, one bears in mind that what's good enough is to say why you've won or lost, but not have to unpick all of that, mindful that this court won't have heard the oral evidence.
You have made... Sorry, I didn't...
Sorry, no.
No.
It doesn't improve with emphasis. It's a bad mistake, I know, my lord. Excuse me. Yes, thank you. So I'm on delay. So I'm pointing to the sections, the reasons given, what they make of the reasons, tenacity of the investigation, and at paragraph 82, you'll see that they don't consider that the reasons as set out are convincing or sufficient. Perhaps if I can just ask you to look at
Well,
paragraph...
that's really up to 84, isn't it? I mean, the whole of the section from 81 to 84 is considering the explanations and rejecting them.
Yes. Or perhaps not even explanations, perhaps at this point reasons. Why did this happen? It happened
Well,
because...
I think explanations is perhaps a better word, but anyway.
In any event.
Yeah.
And of course, it's it perhaps doesn't need to be said, but of course, for the impact of that on a doctor, like, as with any other professional regulatory body, is obviously very serious indeed. So care was taken to sort through the evidence.
Could
I beg your pardon. I beg your pardon, my lady.
Are we still on 82?
82.
Paragraph 82. In the period between 3rd November 2014, the first triage decision, the end of 2016, there appears to have been nothing done by the respondent to progress the allegations. But looking at the chronology, lots was actually going on. We've got the second Hollywood report, the settlement agreement, the IOP hearing, the conclusion of the other case. So I'm just not quite clear what's meant by nothing was happening.
I think it was, there appears to be nothing done to progress the allegations. So I think...
Isn't the Hollywood investigation progressing allegations? Weren't they entitled to
Nothing
wait?
done by the respondent to progress the allegations.
So even if there was all sorts of things, other investigations going on, the fact that the GMC was waiting for the outcome of, for example, the Hollywood report doesn't count. Is that your case?
It's not my case that it doesn't count, but it's...
Well, it doesn't count for the purposes of ameliorating the consequence of delay.
Yes, my lady.
So if there's evidence gathering going on and so forth by a third party, in this case the trust, the GMC remain vulnerable to finding of racial discrimination if it's resulted in delay.
I beg your pardon, my lady. Could you ask me that again?
I'm just
sorry, it's mine.
I'm just trying to understand why the fact that those investigations were ongoing, and I'm just going from the chronology that we've got.
Yes.
Why that doesn't in any way ameliorate or mitigate the issue of delay, and do you think that when it says nothing was done to progress the allegations, that's a fair reflection of what was happening during that period of time?
There are certainly some things being done.
Well, there was the Hollywood, there was the third IOP.
Well, that's not progressive. I think what the tribunal's concern was, my lady, was that there was not much being done by way of investigation. So there was little by way of exploration. They weren't forming judgments on making inquiries, coming to views about the allegations. Once and of course they're entitled to, well, the tribunal accepted, as a matter of fact, that the practice of the GMC was to await the outcome of an internal investigation.
But you say if that resulted in delay, then that has to count against them.
Well, I don't say that. I think the concern of the Employment Tribunal was that there was nothing very much being done by way of taking action to see what happened.
They record at paragraph 80 submission, presumably by Mr. Hare, delays are common in the respondents' investigations of doctors of all races for a variety of reasons. They didn't say, we reject this submission, it is plainly untrue, or we find as a fact that this is nonsense.
I think where I thought they addressed that was para 85, where they say that the respondent doesn't have a system for monitoring the length of time cases were in the system. There's been no data that casts any light on the racial breakdown of those affected by delay other than anecdotal evidence. Whether, I'm not suggesting but that's the closest they come to meeting that point.
Yes. And the way they address it in my submission is by saying there may be lots of cases where there's delay. Tell us what the reason was in this case. There may be another case where there's delay, but tell us why it was in this case. And if it is plain that the explanations they're providing, this is what happened, and the tribunal says, well, no, that didn't happen. As a matter of fact, it didn't happen. Then they are reaching adverse conclusions about the reasons.
Where do they find that the explanations put forward by the respondents are untrue?
We just went through paragraph 80.
Did they say untrue, or did
no,
they
didn't
just
say
not,
untrue.
that they didn't accept?
They didn't accept. They didn't accept.
They didn't amount to a
Precisely.
row of beans, really.
Precisely. That's it. Precisely what it is. They what they were saying was these they were doing this. It's not. Well, your lordship has read it.
But Miss Mullin, just before we go on, can I just say one way of digging into this issue? And I'm looking at paragraph 85 that my Lord Vice President took us to. I don't think anyone, certainly for my part, would for a moment do otherwise than completely understand the stress and strain that the delay will have put upon your late client, and the effect it would have had not just on him professionally but personally, and no doubt on his family as well. So I would hate him as he's sitting in court to think that we weren't cognizant of that and conscious of that.
Yes. So my Lord, Lord Justice Bean was exploring the question of explanations, reasons, and so on, and findings. And the point I make again is simply that they heard what the respondents said by way of what we were doing at this time and what we were doing at that time, and why we didn't do this and why we didn't do that, and said, well, it doesn't add up to a row of beans, or as the case may be. And if one thinks about an ordinary discrimination case, a regular discrimination case, there often isn't a comparator. One is building up a picture from a variety of bits and pieces. Sometimes one can't prove it, but building up a picture often on the basis of what the respondent says. Often a respondent will say something that's plainly untrue. I don't say that here, I'm not saying that here, but certainly a tribunal would be able to say, well, we're entitled to take account of the fact that they have given us a completely untrue story and no satisfactory explanation.
Okay, it's not untrue. It's not satisfactory. It's not an acceptable explanation. That doesn't mean to say it's a lie.
No.
It doesn't mean to say it's untrue.
No, absolutely not. No, and I've certainly
I don't think it was a finding that they...
No, and I certainly, I was using by way of an example a situation where a tribunal is entitled to take account of the account given by the respondent. But in this case, certainly no, it was not suggested at any time that the respondents were lying. It was simply suggested that these really didn't add up to anything. There was something going on here that calls for an explanation. And as I've indicated, perhaps not most, that's probably an exaggeration, but many discrimination cases, there is not a comparator.
You have made that point, yes, and we're very alive to it.
Okay. And
of course, you can infer a sufficient prima facie case of discrimination from a variety of circumstances put together. You don't have to persuade us of that. The question is whether that is the process that was gone through here, and if so, whether it was gone through adequately and adequately explained. And indeed, perhaps, whether at the end of the day, the reasons given are capable of establishing that the threshold was reached.
Yes. And Well,
it's probably better, isn't it, when to get to the end of the conclusions and see how they did reason it, and then you can make your overarching submission.
Well, in fact, that's where I'm going to go to. So if I can ask you, please, then go to the conclusions section, which you'll see at page 128. Comes to the conclusions and takes account of the statistical evidence that you've seen at paragraph 99.
Are you asking us to read that?
Oh no, sorry. I thought I saw your lordship's head down, and I thought perhaps you were reading. But forgive me.
I was reading, but I mean, I was only waiting for you to say what you wanted to say about
no, simply to say they took account of statistics, and they were entitled to do that.
Have we got D181? What document is that?
It's not in the bundle.
Okay.
I think it's State of Medical Practice, which is one of the. I can hear Mr. Hare saying that it's one of the documents.
Okay, well, no, we haven't got it.
We haven't got it. Yeah, okay. Yes. So you have the data there.
Yes.
There's a complaint, as your lordships and your ladyship will have seen, that the tribunal didn't give adequate reasons for rejecting the statistics relied upon by the respondent. You will have perhaps seen in the closing submissions, the written closing submissions, that there were submissions made by both sides in relation to the statistical data, and the tribunal plainly accepted what the claimant said.
Is that good enough? This is obviously, on my reading of this, really the heart of the case. This is the main thing they relied on. Not the only thing. I agree you've taken us through a lot of other material, but this seems to be central to their thinking. And it was clearly the subject of a great deal of challenge and other documents, which are not referred to, and no reasons are given for rejecting the respondent's submission, which we understand was made, that these statistics don't in fact show, or aren't in fact a reliable basis on which to draw any conclusions of the kind which the claimants are arguing for. Doesn't that have to be reasoned out?
Well, in my submission, no. It's clear what the disputes were. They were set out in full in the written submissions, and it's clear that the tribunal has preferred these submissions. It's not, in my submission, required to go so far as to set out in relation to each piece of what might be material evidence, even very material evidence, why it has accepted it or not. It is obliged to say what it's found.
In paragraph 1, the critical paragraph 112 lays great emphasis on those statistics which you've just cited to us. Seems to me to be saying they alone satisfy stage 1 of the process. They alone shift the burden of proof.
Well, they say they take all these matters into account, all the above matters into account. Taking all of these matters into account, we've come to the conclusion that taking into all the evidence, including the statistics. So it's not. I don't shy away from the fact that it's plain that the tribunal thought the statistics were significant.
But the statistics were the only thing which had a racial element in it, over and above the fact that he was badly treated, and he was from a racial minority.
Well, it's not the only thing.
I suppose there's the comparison with treatment of Mr. Lanier.
And there is the equality and diversity in training policies and complacency.
Right, I withdraw what I said. We've skipped ahead. I was forgetting those points.
No,
but certainly this is the one they mention here.
Certainly,
it's the only one, and it's the one it's the one that they rely on in drawing a distinction between his race claim and his religion claim.
Well, it is also fair to say that in relation to the religious claim, there were no comparators identified. There was no evidence directed at that in particular. So in my submission, the tribunal was bottoming that out and saying, and there are no statistics. But you can see from the substance of the decision, there's really, there are no findings that could conceivably, even with statistics, have founded a religious discrimination claim. So in my submission, it's just bottoming it out. It can't be a basis for refusal. There could never have been a positive finding.
Is that entirely right? If suppose, as you say, we have no evidence that they were aware of Mr. Lanieri's race, but it's reasonable to infer that he's not South Asian, and probably that he's not black. It's also probably reasonable to infer that he's not Muslim.
I'm pretty sure we explored all this in cross-examination.
Yes. I'm just wondering, though, whether it's entirely right to say, well, there were other reasons for distinguishing the religion claim, because absence of diversity training would go equally to religious discrimination.
Yes, but we didn't have certainly it wasn't, the comparators were put in relation to race. If one looks at the submissions, this was pursued as a race discrimination case, and you can see from the substantive findings, there are no reference to Mr. Laniardo wasn't a Muslim.
Yes, I see. Okay.
So even where there's masses of statistics at the end, it wouldn't help.
Okay.
It would be inadequate.
Okay, I was just testing
So,
that.
It sounds to me as though it was pleaded but not developed.
I think that might be a kind way of putting it, my lord.
Can we just go back to race? 112, the second sentence of 112, seems to me that they, taking into account all the evidence, including the statistical evidence, shows a higher degree of adverse outcomes. We consider there is evidence from which we could conclude the difference in treatment in comparison with Laniardo and the delay were on the grounds of his race, i.e. the burden has shifted, and then we don't accept the respondent's evidence either as to the comparison with Laniardo or as to the delay. Therefore, the claimant wins. That seems to me to be saying that the statistics on their own shift the burden of proof.
Well, I would invite your lordship not to read it in that way. Perhaps I would say that, but
well, what else shifts the burden of proof?
All of the matters above, taking all these matters into account, that is those that precede this paragraph, and they include, as I've indicated, the stats, they include the equality and diversity training, they include the complacency about discrimination and equality within the GMC, complacency is used somewhere, as well as, of course, the primary findings in relation to the differences in treatment. So it's not merely the statistics. It's a picture, and it's a typical picture in a discrimination claim, as your lordship knows, in terms of running a claim.
But does it apply to every case where an allegation is made of discrimination against a regulator, and the statistics show that the regulator proportionally pursues more of its ethnic minority constituents, if that's the right word, than white ones. So it seems to me a point of very great general importance, if that's so.
Well, it's certainly the case, as your lordship knows, that statistical patterns can be relied upon in direct discrimination cases for the purposes of supporting an inference. And here, the evidence is there are statistical disparities. We rely on those as part of the building up of a picture for the drawing of inferences, just as in West Midlands and Singh with the, almost no Asian bus drivers, whatever it was, I can't remember now, the earliest case on statistics in direct discrimination cases. It's one of the features. So yes, my lord, if this was a different regulator, if it were the Bar Standards Board, and the Bar Standards Board had a case against them and there were disparities in outcomes, whether race, sex or otherwise, a claimant would be entitled to say, well, I've been differently treated. You've heard their evidence, it's not convincing, haven't got to shift foot stage yet, but you're entitled to listen to it. And there are no equal opportunities policies, and there are disparities in statistical outcomes, and so on, whatever they may be, and build a picture. And that's the only way one can ever hope to succeed in a race case, except for when you have somebody, a witness, who's daft enough to admit it. And that
it's not just
I've
I've been differently treated, I've been badly treated in respect of delay. Because as you say, there's no comparator in that part of the case. So I have been badly treated. The statistics raise a prima facie case. Over to you, respondents.
Over to you, respondents, once we've leapt over the equal opportunities policy, the complacency, and we've dealt with Spire, which we haven't come to yet, as an example of a pursuit of an allegation that they ought to have realised wasn't going anywhere. But yes, my lord, and those are the sorts of cases that Anya, King, and so on, West Midlands, they are concerned with building up pictures. Qureshi, they all say. And as Lord Justice Sedley said in Anya, things like saying, well, delay is common, or in that case, hostility is common, you've got to have an evidential basis for it.
It's very different.
Well,
hostility is very different.
No, it is, but I mean, the other example is unreasonable treatment. So it's not uncommon, as I said, and I was making this observation earlier on, that it's not uncommon for a respondent to say, sometimes quite rightly, with perfectly sound, good, proper reasons, there was some incompetence in the department. They never did anything right, or they never turned up at work on time, which is why things didn't get done. It's nothing to do with race and so on. But the simple point is there is an evidential burden on a respondent to show, not a legal burden, but there's an evidential burden to provide some basis for a case that something or another is a reason for something or another happening.
Anyway, as inevitably happened, we're anticipating your final submissions, but without having quite got through all the building blocks. We've looked at 99, and you've explained why you say it was unnecessary for the tribunal to say more than they did. Then the next section is on diversity training.
Yeah, and equal opportunities policies.
Yes.
I don't need to take you to that. I'd invite you to read it, but I know your lordships have, and your ladyship, but I simply make the point that they are observing that there's a degree of complacency. The training seems to be a bit sporadic. Not all of them have had unconscious bias training and so on. And that was something that was directly addressed in particular by me by reference to the Code of Practice, which your lordships know and your ladyship know is admissible in proceedings for the reasons given under Section 14 of the Equality Act 2006. And then 107, may I take you to that a little more carefully, and I'm going to bring my note up so I don't And then looks, so 100 got some background evidence that we've just looked at. 107 comes to the comparator question and the comparator test. 107. We are asked to make a comparison of the cases of L and the claimant, and I emphasise this. For this purpose, we must be satisfied that there is no material difference between the circumstances relating to each case. So pausing there, they apply the right legal test, section 23. We note that in the case of L, the Hollywood report found there was an issue of probity and dishonesty. Pausing there, that comes from my cross-examination of Mr. Smythe. I asked him, and it's just so you have a cross-reference, it's referred to in the closing submissions, supplementary bundle, page 43. So I cross-examined Mr. Smythe. I cross-examined Mr. Smythe on the basis that when one looked at the Hollywood report in relation to Mr. Laniardo, and you can imagine there was extensive cross-examination on these matters. When I asked him about that, I said the MDT allegation, I'm simplifying it, it's in the closing submissions. I like to think my cross-examination is better than this, but it probably isn't. That the allegations amounted to allegations that went to probity and dishonesty. And that was accepted by Mr. Smythe. So they pick up that point, and we say there's nothing surprising about that, CDMDT, in respect of the signing of the letter. This is comparable to findings made in the claimant's case on this issue. That is a matter of judgment, fact and judgment for this tribunal. Having heard the evidence, respondent considered there was a link in the case of Mr. L, we're now on to delay, as they did with the claimant. This is not delay, forgive me. Respondent considered there was a link with the case of Mr. Laniardo and Mr. Motawala as they did with the claimant. In Mr. L's case, the respondent considered that this did not need to hold up the index concerns. It does relate to delay as well. So you'll recall when your lordships and your ladyship just looked at the delay questions, one of the issues was, well, we had to wait for Mr. Motawala, we didn't want to interview everybody twice, and so on. Whilst in the claimant's case, it remained linked, resulting in further delay. In the case of Mr. Laniardo, took account he was operating in a dysfunctional environment. We saw that in the closed-down decision, but in the claimant's case, any such recognition wasn't given the same weight. So the respondent's finding there's a difference in treatment, and there is a benevolence being afforded Mr. Laniardo. Those aren't the words he used, and I don't think they were the words used below, but if I can just characterise them in that way for the moment. That there is taking account of the environment in which he's working, it's stressful. They're all, by the looks of it, they're all fighting with each other, reading between the lines, and that's a matter that's taken into account by the GMC, but not in the case of the claimant. And that is a matter for their judgment in my respectful submission. And then paragraph 108, having raised those points, concluded that there's a difference in treatment in relation to the comparison with Mr. Laniardo. And then the Spire. You see that at paragraph 109. Respondent was looking for material to support allegations against the claimant rather than fairly assessing matters presented. And if I can take you, we don't have the notes of evidence, of course, but if I can take you to the evidence that we do have in relation to Spire. This is the applicant's, the claimant's supplementary bundle. And at page 18,
Telephone note.
Telephone note from Mr. Palfrey.
Yep.
Following her,
So sorry, I'm behind. Which bundle
sorry,
are we in?
we're in the Claimant supplementary bundle, so the Appellant
Which page are we
bundle.
at?
I'm looking at page 18.
Thank you. Yep.
And this is a telephone note between Edward Palfrey of the Trust and Lucy Galbraith for the GMC. And the first sentence tells us the context. Mr. Palfrey called Ms. Galbraith following her letter to the Trust regarding the Spire concerns highlighted by Mr. Charig. So there had been some reference to concerns.
Do you want us to read this?
Perhaps you should just read it. Perhaps you, if you wouldn't mind focusing on the penultimate paragraph, but yes, if you just read it.
TH is who?
I assume it's somebody in the Trust.
Timothy Ho, the director at Spire.
That's Spire, thank you.
No, trust director.
No, it's the Trust Director. It's the Trust Director.
Yeah, let us just read. Remind me who PS is?
Sorry?
Sandy.
PS?
Sandu,
Mr.
Palmer
Sandu.
Sandu, Mr.
Yes,
Sandu.
of course, thank you. Yep. Okay.
So we have that note. And then in the meantime, we have materials being sent by Lucy Galbraith to, for example, Amrit Rao at page 19, 9th of March, bottom of the page, page 19. Further to a conversation last week, I'm in the process of investigating a registrant and your name has been given to me who may be aware of an incident. In order to try and establish what you know firsthand, my email will be rather vague. In essence, I've been informed that you've been told someone about something you've witnessed at the Spire Hospital regarding a colleague. Have you any concerns? And at page 22, just to give an indication of how that plays out, page 22, Dear Lucy, you've been really very vague. I'm unsure whether the following concerns were discussed at all at the Spire. Most of my discussions at Spire would have been with Jas Kelsey, clinical lead. Been very unusual for me to have discussed the following concerns publicly with them at all. Whenever we've discussed anything, it's usually when the two of us are alone. You have got me worried that someone was snooping on us and reported something to you. So it's all terribly vague. The inquiries are all very wide-ranging. And then if one looks at I'll take you to the Spire response itself, page 58. We see page 58, to the Assistant Registrar, August 2015. Referring to point E, where the letter states the allegation that Mr. Karim influenced or manipulated the Medical Advisory Committee at Spire to raise a vote of no confidence against the hospital director, Mr. Palm Sandu. So Spire have been written to about that. We've investigated this accusation and we'd like to state the following for clarity. Spire Thames Valley MAC is advisory, performs no executive function. Purposes.
I'm sorry, it helped me. We're in a lot of detail here without very much context. What's all this meant to show?
This is to show that the respondents, that there was an evidential basis for the tribunal's finding that they had pursued certain allegations with tenacity, including Spire, that then remained extant until 2017. And I'm simply pointing out that there was an evidential basis for that. They make inquiries of Spire with little or no basis. They are then being responded to by Spire, for example, 7th of August, and then continuing so that as 78, we see a further letter from Spire, this time in December, answering the questions again, in particular having been asked to provide minutes, does so, and at the bottom paragraph, please note your letter refers to Palm Sandu having been dismissed. Not the case. He was removed to another hospital, and so on, and he's currently employed on a fixed-term contract. Hope this provides you with the information you require to complete your investigation. So they've answered the questions, they've provided all the documents. So there's little to see in any event. They've got what they can, and they keep at it.
What do they do after that?
I beg your pardon?
You say they keep at it. I'm just wondering what you're saying they did after that.
After that, they just kept it with the complaints, so they didn't bring an end to the investigation in relation to those. Those continued until the RPT decision.
But they didn't do anything active, I think.
They didn't do anything active.
No. It sort of lay there.
Well, it lay there.
You're saying they should have been proactive and dismissed it.
Absolutely.
I understand.
Yeah.
And were these eventually counts put to the MPT, or were they dropped?
Not Spire. No. But it did form the subject of the RPT. The reasonable prospect test document. And so I was showing you the evidential basis, and may I just give you the factual findings? Mindful this is only a background fact, but it is one of the matters that the tribunal's been drawing on.
Certainly, yes. I thought you did show them to us when you were going through.
109?
Paragraph 54 is the submissions made in relation to it, and 55.
Certainly showed us 109, which I think
So I'm showing you the
You
background.
showed us
to
56. I
So-
looked it up.
So, and you'll see the end of 56, which I think your lordships have seen. And then 81. A point I already drew your attention to, and just to bottom that out. 81, the tenacity point. Note, and 82, noting at the bottom of the page, 82, last line of paragraph 82, allegations were resolved by the 16th of December 2015, and we just saw that in the letter that I just showed your lordships. The tribunal's taking account of all that, bringing it together under 109 and saying this is one of the matters. This is an example of the way this is being handled, among other matters, all the matters that precede it. And then, if I can take you please to 110, I've nearly finished, as you can see from the number of paragraphs left in the decision. 110 does identify significant delay. In my submission, that's a matter for their judgment, having heard the evidence
from the witnesses as to what was happening. And as they say, much of the delay arose because of the linking of the allegations, not necessary. 111, the complacency points.
Hang on, can I just understand what is being said in 110? There was delay because of the link, mostly because of the linkage. The linkage was a matter of convenience, not necessary for justice to be done. But that by itself doesn't raise any racial inference, does it?
No.
The administrative convenience of linking the cases for the purpose of the investigation is extinguished when the investigation is concluded in either case. That, I suppose is true, but I'm not quite sure what point they're making there.
Well, I think they're making the point, my lord, that if they had, it doesn't help the respondent, because if they had resolved the claimant's allegations earlier, it would have become disentangled from Mr. Motawala's.
Yes,
So necessary either case, the administrative convenience of linking the cases is extinguished when the investigation is included in either case. In the claimant's case, much of the evidence was available from
yeah,
an
okay,
early
and
stage.
that's helpful. I just hadn't followed it through the thinking. Okay.
And then we've explored paragraph 112 rather than repeating myself more emphatically, which would just irritate the court. I know. I haven't got anything else to say about that. Those are my submissions on the decision, unless your lordships or your ladyship have any questions. So far as the Employment Appeal Tribunal decision is concerned, and I've discussed this with Mr. Jupp over lunch, and we're content to invite your lordships and your ladyship to read the skeleton argument and the references in the skeleton argument. There's nothing I can add by way of value.
Well, you don't really lose anything by doing that, because you quite rightly, if we think that this stands up, then by definition the EAT
Precisely.
decision doesn't. If there are particular points made by the EAT which you haven't dealt with, they'll be incorporated in Mr. Hare's submissions, and you can answer them in reply.
I'm grateful.
Yes. No, well, that's very helpful.
I beg your pardon, I've just got one. Sorry, I'm being nudged, so this is leading a leader.
Yes.
Thank you.
Maybe Mr. Jupp's very last time in that back row. He's enjoying annoying his leader while he still has the chance.
Well, your lordship could invite him to undertake some of the submissions.
Probably doesn't apply now, does it?
No, that's...
Well,
Yes, Mr. Hare.
I know.
Sorry, thank you. I should have said thank you, Ms. Mollett. That was a very helpful exercise. Yes,
well,
Mr. Hare.
Before setting out the structure of my oral submissions to the court,
Can you speak up a little? You're dealing
Today.
with at least one rather
Yes.
deaf old man.
I've been told to tone it down a bit in the past, so I'll try and choose the perfect.
Well, either I've
for
got
you.
deafer or you've got more
Yes, it's possible. Not by your lordship.
softly
Yes,
voiced.
yeah. Before I set out the structure of my submissions then, I did just want to correct one error in my, there may be more than one, but there's only one that I've noticed in my skeleton argument.
Yes.
I'll do it very briefly. It's in paragraph 20, where I put in a sort of table, bullet point form,
Yep.
differences between Mr. Laniado's case and Mr. Karim's at the date of the second referral to the IOP.
Yes.
I say there they had the final Hollywood reports in relation to both. That's not correct in relation to Mr. Karim because that didn't come until April. I apologise for that. They did have reports in relation to both of them, which was a final report in relation to Mr. Laniado because there was no further report. But the report in relation to Mr. Karim was later. So I'm sorry about that, and I hope it didn't cause any confusion. My Lord, what I propose to say in my oral submissions would follow the following structure. Before I go through each of those 4 points that was found against the General Medical Council by the Employment Tribunal. And I'm going to follow the pattern of my learned friend of focusing on what the Employment Tribunal said, taking the court, I hope, some of those documents that we've included in our supplementary bundle. I did want to say something briefly about the statutory context in which the General Medical Council operates. It's obviously very different from an employment situation, and we say that some aspects of those differences are relevant to the way in which the Employment Tribunal should have approached this matter. And I wanted to say something very briefly as well in relation to the context. That's particularly relevant in relation to statistical evidence about disproportionate impact on different groups. It's a point made by my Lord Justice Bean, just to make it good, as it were, by reference to some of the documents that the court has. This matter is extremely important because the sort of disparities relied on by the tribunal here, and the court's focused to some extent on that paragraph where they're set out, are common across all healthcare regulators, and indeed the majority of regulators in other contexts. And I'll just take the court very briefly to a passage in one of the research documents that have been put before the court, which make that good. We say that those two things, the statutory context and that matter, is an important part of the context. And then I'll get on to doing the individual findings that were made against the GMC. Could I invite the court to take up the authorities bundle, please? I wanted to start at tab 1 with the Medical Act, and then from there to say something about the 2004 rules. The starting point, not surprisingly, is section 1. That's on page 3, tab 1 of the authorities bundle. Section 1 sets out the overarching objective of the General Council and sets it out in those familiar terms, the threefold division as it's often described. The overarching objective is the protection of the public in exercising the General Council's functions. That means what's then set out in section 1, brackets 1b, A to C, protecting, promoting, maintaining health and safety, well-being of the public, public confidence in the medical profession, and promoting and maintaining proper professional standards and conduct for members of that profession. Now that overarching objective, obviously being called the overarching objective, applies to all aspects of the GMC's activities. The next relevant part of the Act is section 35C, which the court will find at page 10 of the authorities bundle. Headed in section 35C1, this section applies where an allegation is made to the General Council against a fully registered person that his fitness to practice is impaired. And that is the crucial statutory inquiry that the GMC is undertaking. Subsection 2 goes on to limit the matters which may give rise to impairment to fitness to practice. And the court will no doubt be familiar with those from other contexts, but the court will notice straight away that we're, in this case, dealing with matter 2A, misconduct. But the court will also see that, for example, there's been deficient professional performance. Now, the reason I make that point is because what the GMC is concerned with is not misconduct in the way that an employer might be concerned, for example, with an allegation of misconduct. The question for the General Medical Council is whether an allegation or allegations of misconduct give rise to a concern about the registrant's fitness to practice. In other words, these are, as it were, categories, misconduct or deficient professional performance, lines down which those investigations may go. But the investigation must never lose sight of the fact that it's not a trust carrying out a disciplinary investigation into a doctor for shouting at a colleague on a busy ward on one occasion, for example. General Medical Council is concerned with the overarching question of fitness to practice. The reason I emphasise that, my lord, is that what we say the tribunal did below, and what, with respect, my learned friend has done before this court, is to assume that you can separate out certain elements of the allegation of impairment of fitness to practice and say, well, this is similar, or a bit similar, to something that arose in relation to another registrant. When the question before the relevant decision maker, and I'm going to take the court to those relevant decisions in a moment, was the overall impact of all of those allegations on the key question of impairment of fitness to practice, not whether there might be an example of misconduct here or there. The crucial difference is, I'm sure the court's very well aware of this, take the example of deficient professional performance. Generally, a one-off error, even if it may constitute medical negligence, wouldn't give rise to an issue of impairment of fitness to practice. Probably wouldn't be investigated. If there is an investigation, it's likely that it would be concluded, as it very often is, with what's called a performance assessment, where there are several days set aside and the doctor has to go through the motions that they would go through professionally, or whatever their specialism is, sit examinations, all those sorts of things. In other words, the point I'm making, but I hope I'm not labouring it, is that this concept of impairment to fitness to practice is by definition a holistic concept. It involves looking at the whole of the registrant's practice and the whole of the allegations that have been made against them. In the misconduct context, and the court will have seen a reference to it in my skeleton argument, very frequently, as I said, a case of a doctor shouting at another doctor on a busy ward round probably wouldn't give rise to a fitness to practice matter and probably wouldn't even be referred to the General Medical Council. But if there's a pattern of behaviour, even if the individual circumstances of misconduct are not as serious as might justify action on their own, if there's a pattern of behaviour, then that can necessarily, or will, is likely to, give rise to a concern about fitness to practice. And we see that in relation to all of the allegations that were progressed, and it's a point made by, at various points, by assistant registrars, by case examiners in Mr. Karim's case. If one thinks about all of the allegations that were proceeded with, they all related to an attempt, in one way or another, to protect Mr. Motawala. Remember, the MDT letter was about one of Mr. Motawala's patients. The canteen meeting where Mr. Karim challenged Mr. Rao was because Mr. Karim suspected that Mr. Rao was the author of an email criticising Mr. Karim. The attempt to persuade, not putting it no higher than that, Dr. Robinson to withdraw his witness statement was in relation to a GMC investigation into Mr. Motawala. The contact with Dr. Hayter was in order to obtain documents about one of Mr. Motawala's patients. Yes, so all of those matters, as it were, we say, well, this is what the contemporaneous decision makers were saying, give rise to a concern about a pattern of behaviour on the part of Mr. Karim. And if you don't find evidence for a similar pattern of behaviour in relation to the comparator, a crucial element of what gives rise to the fitness to practice concern simply doesn't exist. So we say it is an error to try and separate out the individual allegations and try and compare them.
If we were to look at, I'm not asking you to take us to it, if we were to look in your closing submissions, we would find that point, would we?
Yes, well, yes. I put it in a number of ways, but the way in which I'm going to develop it now by reference to the rules, I think, is the way I put it below. And perhaps
I meant about a pattern of behaviour.
Oh, yes.
A common theme being Mr. Motawala.
Yes, absolutely.
Okay.
Oh, yes, that was very central to our submissions.
Yep.
That's the point on that. The last thing I wanted to show the court under the Medical Act was Section 41A, which is the test for the Interim Orders Panel, Interim Orders Tribunal as it's now called, that the test is the same. it should be on page 30, going over to page 31, still in tab 1. If you have that, my lord, then 41A brackets 1, where an interim orders tribunal or an MPT are satisfied that it is necessary for the protection of members of the public, or is otherwise in the public interest, or is in the interest of a fully registered person, for the registration of that person to be suspended or to be made subject to conditions, the tribunal may make, and then there's a list of the relevant order, essentially conditions or suspension. And we say that test as well is one which requires a holistic assessment of the allegations together, taking account of any potential pattern of behaviour and so on. Or if I could invite the court to turn next to the 2004 rules. They begin at page 44, same bundle, tab 2. There were just 3 points I wanted to show the court here, if I may. The first is the linking, and I'm looking here at paragraph 2. It's in schedule 1 of the rules, and the court should see there on page 47 is the definition section. The act obviously means the medical act. Allegation means an allegation that the fitness to practice of a practitioner is impaired. In other words, that what I've described as holistic concept of fitness to practice, not misconduct, not deficient professional performance, but the overall question of fitness to practice is what the allegation is concerned with. It also sets out what the case examiner is a little lower down there, but I don't propose to read that out. The crucial part of the rules themselves, the first crucial part, is Rule 4, to which the court has heard reference. That's sometimes called triage. Under Part 2, investigation of allegations, initial consideration and referral of allegations. An allegation, we've seen how that's defined, in other words, an allegation of impairment of fitness to practice, should initially be considered by the registrar. Those powers are exercised, have been lawfully delegated to assistant registrars, of which there are a number. But the triage decision is made by an assistant registrar, as is the decision about whether or not any further information is adverse information. Crucial part of the test, of course, is in Rule 4.2, subject to other paragraphs which don't concern this case. Where the registrar considers the allegation falls within section 35C2, that's the section I just showed the court of the Act, he shall refer the matter to a medical and a lay case examiner for consideration under Rule 8. So the crucial point is that that is a duty, it's not a discretion. Of course, there has to be a judgment exercised about whether or not the allegation falls within section 35C2, but as soon as it does, that duty is triggered. There are then provisions on investigation, of course, but the duty is to refer the matter to the case examiners. And the case examiner's powers are set out at Rule 8. This is the point I was making, and perhaps I rushed it before the short adjournment when I stood up to say there's nothing, as it were, in between triage, between Rule 4 and final consideration of the matter by the case examiners under Rule 8. My own friend was using the term review, that the investigation against Mr. Laniado was reviewed by the case examiners. Why didn't they do that in relation to Mr. Karim until 2017? And the answer is they have no power to do so. The power of the case examiners is to consider the case referred to them by the registrar at the conclusion of the investigation. And the case examiners there have a number of powers. They could decide that the allegation shall proceed no further, and that's what they did in relation to several of the allegations against Mr. Karim, as we know. Or D, I'm looking at 8.2. 8.2D, they can decide to refer the allegation to the MPTS for them to arrange for determination by a medical practitioners tribunal, which is what they did in relation to some of the other allegations against Mr. Karim. But the crucial point remains that there is no scope for the case examiners to review the decision. when the case examiners closed Mr. Laniardo's case in November of 2015 and decided they would not proceed further with it, that was the end of the matter. That was under Rule 8 when it had been referred to them by the Assistant Registrar for final disposal. And they decided that the allegation there, the only remaining one against Mr. Laniardo at the time, should not proceed further.
So that wasn't strictly a review.
It wasn't a review at all.
It was a decision under Rule 8(2)(a.
Yes. That the allegation should not proceed further. Yes, precisely. Thank you, milady. And the tribunal below, in fairness, accepted that at paragraph 39. But the point, I suppose, is to come back to another term that was used earlier today. There's no continue the investigation document, as it were. No, there isn't. Once an investigation is opened under Rule 4, it continues until the matter is referred at the end of the investigation under Rule 8 to the case examiners. Now, there are then two elements of the GMC's practice which apply to all doctors, and I don't believe are disputed. The first is that all allegations of the same type, in other words, misconduct, say, as in Mr. Karim's case, are referred to the case examiners at the same time. So the case, the overall allegation of impairment, coming back to what I was saying previously, that the allegation is an allegation of impairment to fitness to practice. So even if an investigation is concluded 2 months in, if there are other elements of the investigation that is ongoing, the earlier part that's concluded is not any doctor, not referred to the case examiners under Rule 8 until all elements of the investigation are completed, and then they're referred at the same time to the case examiners for a decision on all of them. Even though, as we've seen, in relation to some matters, you saw the realistic prospect test document that my learned friend, it was perfectly clear that in relation to the first issue on that list, that was resolved by the Hollywood report in Mr. Karim's favour. That is to say, it was resolved by, at the latest, April of 2015. But it was still being considered for referral to the case examiners under Rule 8 in 2017. There'd been no further investigation of it, but there's no mechanism for it to be considered separately and closed separately. Now, the court may criticise the General Medical Council for that, particularly like these matters may be hanging over the doctor. Well, of course, that matter probably wasn't hanging over the doctor because he'd seen the outcome of the Hollywood report and he knew there'd been no further investigation of it. But that is not a discriminatory, or not evidence from which this court or the tribunal below could infer discrimination. It's also the GMC's practice, again applied to doctors of all races, to await the outcome of an internal investigation, usually by the trust, before it starts any investigation of its own. And again, I don't understand that to be disputed. My lords, my lady, they're the only elements of the statutory, as it were, and practice background I wanted to deal with.
Do we need to look at 29th of February investigation resumes when Rule 12 process concludes? Just wondering what Rule 12
yes.
Do I need to
Well,
know?
that,
If I don't need to know, don't burden me with it.
that was a complication to Mr. Motowala's investigation. So it relates to the fact that the two were linked. So Mr. Karim's investigation was linked to that of Mr. Motowala. Of course, return to that in relation to delay.
Of course.
But in Mr. Motowala's investigation, it was revealed that there was an additional matter that hadn't been previously looked at, and that required a Rule 12 review, which took an additional 6 months. So it did add to the delay.
Thank you.
But I don't think I need to say any more about that at this stage, my lady, if that's satisfactory. No, please. So I wanted to say then something about the factual context. One of the bases, as I know the court is well aware from the points that were made to my learned friend, one of the bases upon which the GMC, a fundamental part, in fact, of the GMC's defence of the proceedings, and our specific response to the statistical evidence, was to place before the tribunal below several hundred pages of research findings, which the GMC generally has commissioned, into acknowledging, in other words, this disparity and trying to obtain proper qualitative analysis of whether any aspect of the GMC's processes contribute towards it. And the principal document we relied on was the University of Plymouth report from 2014, which is in our book. But I wanted to show you a document that was produced, another set of research commissioned by the General Medical Council, following on from that document, which is the document called Fair to Refer. One of the points made in the research that the GMC conducted, and this is in, sorry, it's tab 16 of my learned friends, what was the unagreed supplementary bundle put in by the appellant. And it's, as I say, tab 16, beginning at page 93, a document called Fair to Refer from 2019. And the names of the authors are set out there. It was research commissioned by the General Medical Council after it had received the outcome of its own, the Plymouth University research, which said that there was no evidence of racial discrimination in the GMC's policies. And the GMC then commissioned some research into whether further steps could be done to address the fact that referrals to the GMC of black and minority ethnic doctors, the GMC can't control that, but whether or not any further research can be done about that, and anything could be done by the GMC or responsible officers in trusts to try and address it. And the passage I wanted to show the court is on page 112, under the heading Overrepresentation of Some Groups of Doctors. I'm not going to read all of this out, but can I just start reading it and then indicate which other parts we say are relevant? A continuing source of concern over the last 2 decades has been the treatment and experiences of black and minority ethnic doctors in the UK, including their entry to medical school, quoting research there from 1993, postgraduate RCGP exams outcomes, research from 2014, and the impact of the discretionary points award scheme for doctors, again, further research in 2003. In other words, evidence of disproportionate outcomes in relation to those aspects of medical education and certification.
Is it discretionary points award scheme? Is that what used to be called merit awards?
Yeah, yes, I think so. I'll confirm that, my lady, but I think so. The crucial paragraph is here. I'll read this one out as well, if I may. Across all healthcare professional regulators, the rates at which registrants are referred into the fitness to practice processes are higher, black and minority ethnic registrants, than they are for white registrants. And there's a series of research findings there, some related to the GMC, some to the General Pharmaceutical Council, some to the NMC. There's a paragraph there about reports.
And the referrals will always, by definition, come from third parties.
Yes, precisely. And we've seen what happens when the GMC receives a referral. It has no discretion under Rule 4 if it falls within the definition of an allegation, that is to say, it may give rise to a concern about fitness to practice. It has to triage it into investigation. This is why, with respect to the point made by my Lord Justice Bean earlier on, I was hoping to reinforce it's extremely significant for healthcare regulators generally, and not just healthcare regulators, if it is sufficient to point to some statistics and use that to base an inference of race discrimination without considering this mass of other evidence and massive evidence about the widespread nature of the concerns. So across the healthcare sector I've set out, if I could skip 2 paragraphs to a paragraph beginning in England, penultimate paragraph above the table, where comprehensive data exist, the NHS, for NHS staff as a whole.
So where are we reading from?
Sorry. So I'm now down to the 5th paragraph, I think it is.
But on which page?
Beginning in same page, sorry. Page 112.
Right.
In England, where comprehensive data exists, for NHS staff as a whole, black and minority ethnic staff are more likely to enter local disciplinary processes. In 70% of NHS trusts, the likelihood of BAME staff entering the local disciplinary process is more than for white staff. In over a quarter of it. Well, the court can read the rest of that for itself. There's no point by reading it out. But we do say that it is very significant that that's the case. The fact that it is the case, and the fact that specific qualitative research has been commissioned and carried out from respectable academic sources by the General Medical Council and others cannot be dismissed out of hand and must be addressed. If a tribunal is going to try to base an inference simply on the quantitative data, because the quantitative data applies equally to all of these different regulators. And it applies to the SRA as well. There's further references to that, but I won't trouble the court with them now. I hope I've said enough to make the point. The GMC can't affect inputs. That is to say, it can't affect referrals, whether from individuals or trusts. And as we see, there is over-representation of black and minority ethnic doctors in trust disciplinary processes, and they very frequently, of course, lead to referrals to the General Medical Council. We say that's a crucial part of the context of this case, and why the quantitative research that the GMC relied upon at length before the Employment Tribunal is so significant, and why its omission, any reference to it, is so significant.
Well, yes, at the moment, I feel welcome to look this gift horse in the mouth, and I may be overstating it. At the moment, if this material is reliable, it seems not just to have to be taken into account, it seems wholly to undermine the figures, the relevance of the figures at 99, which may all be true, but if they show anything, they show discrimination by trusts,
Yes.
not by the GMC at all.
No, and that's why I wanted to link
Which is,
this.
so unless you can say that, I don't know how you say it, maybe Mr. Bonham will tell us in reply, but the least one can say is that this would have, the tribunal would have to explain, in the light of seeing how GMC gets its caseload, why that didn't completely undermine, sorry, that mid-afternoon time where I'm not making much sense, but yes. Basically, Para 99 is worthless unless you can explain why it shows discrimination by the GMC rather than by the referrers.
Yes. Yes. And then you put that with the Plymouth University research, which scrutinised. Should I show the court that now? Yes. But you've seen it, I think. Yeah. Oh, you haven't? I'm sorry.
Well, where would we have seen it?
Well, no, of course. Well, could I just show it to you then, very quickly? I'll try not to.
It's in the bundle we got this morning.
It's in the GMC's supplementary bundle.
Yeah, that's why we haven't seen it.
Yes.
The figures we were just looking at on page 113 of the bundle. This is complaints by patients as well as complaints by.
Yes, I think that is. Yes.
So it may show that patients are discriminatory.
Yes.
It may show that trusts are discriminatory, but you say it doesn't show that the GMC are discriminatory.
Yes. So it's putting together these different elements. The first is the fact that the GMC has no choice but to open the investigation because of Rule 4 if it falls within the definition of an allegation. You then look at what the source of those allegations is. Of course, in some cases it's members of the public, but in many cases it's a trust.
Yes.
And then you look at the Plymouth University research, which I'm just about to take the court.
Yes.
An in-depth quantitative research project in relation to the GMC's processes. It's the GMC's unagreed bundle. Review of decision making in the.
So which page?
131.
131. Yes, because so this deals with what is the key question: is once you've got it, are the outcomes, either in terms of delay or more importantly in terms of decisions, disproportionately worse for BAME recipients, subjects of complaint?
Yes. Can I correct one thing which is in the index to the bundle? As the court sees, the date of this report is December 2014. That's why it's thought to be particularly relevant. It's not 2004. That's just a typo on the index. I'm sorry about that. But that's why it was relied on. Obviously, this is in the core of the period in which Dr. Karim's case was being considered. As I say, I'm going to take it swiftly, but could I invite the court to look at the executive summary on page 137, please? So essentially the first paragraph, which I'm not going to read out, refers to the evidence that some demographic cohorts of doctors, male doctors, older doctors, non-UK trained doctors, black and minority ethnic doctors, overrepresented in FTP procedures. This report presents...
Well, hang on, sorry, but there are 2 points there. Overrepresented in the procedures, that effectively means getting into the process.
Yes.
Referrals, in other words. Then... Secondly, are at increased risk of progressing further through the system and receiving higher impact outcomes. Yeah, well, that is more significant.
That's more significant, but that's why the fair to refer document doesn't answer the case that might be made against us.
No.
Because you could still say the outcomes are worse.
Yeah.
The crucial point, of course, an outcome, you might say, of Dr. Karim's case was that he was subject to investigation for a very long period
It may
of time.
not answer the case against you, sorry, just before, but para 99 of the ET's decision simply doesn't make any distinction between referral. Yeah.
No, it doesn't. And the statistics about outcomes, Dr. Karim wouldn't be in those.
Quite.
Because there was no outcome imposed by the MPT. There was no sanction imposed in his case because the case of impairment wasn't made out. So his case doesn't, those statistics on outcomes don't help him.
No, you might have sophisticated statistics which showed that even though outcomes were worse, well, outcomes were no worse, nevertheless they were more intensively reviewed and so forth.
Well, we don't have that.
No.
So all the statistics
no particular reason to believe it would be the case.
Forgive me, my lord. No, I didn't mean to speak over your lordship. But what the statistics show, and I think the tribunal accurately reflects this and says this, is that entry into the disciplinary process and outcomes are disproportionate. The outcomes bit of that, you could say that just provides a general indication of discriminatory practices. You could argue that. But there was no adverse outcome, which would have counted in Dr. Karim's case in the statistics because he wasn't found guilty of, there was found to be no impairment. So this is what this investigation was about. But this report, I'm back on page 137, just under the passage looked at a moment ago. This report presents findings from an in-depth qualitative review of GMC decision-making within the FTP procedures, which aimed to identify instances of bias or discriminatory practice, and more generally to assess the quality of GMC decisions and decision-making processes. The second bullet point I'll just read out, if I may, under research questions. What factors within the GMC's purview contribute to the overrepresentation of demographic cohorts of doctors in the FTP procedures, if any? So that was the question that was being addressed in this research head on. The aim was to find out if the GMC's processes and decision-making contributed to that. Now, just to make 2 more points, if I may. There's a very lengthy section on the method. They call it methodology, but the method that was adopted by the researchers. It involved interviews, it involved sampling case files, it involved going through GMC decisions and so on. But there are 2 core elements to it. The first was, all of this was emphasised in my skeleton before the Employment Tribunal, which I know your lordship has read, for example. I went
Skeleton, you mean closing submissions?
I do apologise.
Yes.
My closing submission before the Employment Tribunal. 2 points about that method. The researchers, it was a multi-author document. You've seen there were 6 different academics who were working on this research project. The authors were satisfied that the sample they chose was statistically adequate for the purposes of the research project and the questions they were asking. Very difficult to question that unless you have expert evidence to say that the sample size wasn't actually big enough.
I'm not stopping you, but we mustn't lose sight of the fact that you don't have to persuade us at the moment just how strong an answer this is to any statistical case against you. All you have to persuade us of it was sufficiently strong for at least to require to be dealt with.
Well, then I could perhaps stop there, but I'm anticipating what was said below and what may be said to the court now, which was a series of points were made that the sample size wasn't actually big enough and so on. And obviously we responded to that saying, well, that should have been a matter of expert evidence if it was going to be challenged. But in any event, the only point I was going to make is that's irrelevant in this case because, and I won't take the court there, but page 190, the researchers identify that the disproportionate representation of black and minority ethnic doctors was present in their sample. So even if you said the sample was too small, and they said, they're the experts, and they said the sample was of the appropriate size, and they say that it's pages 143 to 149, I'm not going, and 147, sorry, that's within 143 to 149. So it's that passage where they describe
that again. You were peppering us with different
I
page
was, and I
numbers.
apologise.
I thought we were on page 190.
Well, I was there as well, but I was just trying to give the court the references to where the researchers say we are satisfied that our sample size and research methods are robust. And that's 143 to 149. But, I said, even if you weren't satisfied of that, you still have to deal with the fact, at 190, that the researchers noted that the disproportionate representation of black and minority ethnic doctors was present in their sample. And their conclusion, 138, last thing I'll show you, thought on this. 138, so, well, I'm taking you to the summary of it, my lady, but I hope that's sufficient for present purposes. They have a section on 138 called Core Findings. No evidence of bias or discriminatory practices was identified, either in the GMC's guidance and criteria documentation for decision makers or the sampled case files. So that's why we say this evidence was so significant that it needed to be addressed. And it's significant.
So just to be clear, this is not, in fact, this does not attempt a statistical analysis. What it does is it samples a series of files, trying to make sure they're representative, and makes value judgments on those, on the what happened in those files.
Well, value judgments, the exercise of the academic expertise of the
All right, value judgments isn't a dirty word from my point of view.
No, well then value judgment. I'm very happy with that, but they're expert value judgment.
Expert judgment, yeah.
No. Yes.
Okay, that's fine.
Yeah. The statistics are in those documents which come out every year, the state of medical practice. And that's where the statistics that were relied upon by the tribunal are to be found.
Yeah, but just to put this to bed, you could have had, but maybe nobody's ever done this or wasn't helpful, somebody doing a statistical analysis saying, of all cases once referred, outcomes are worse for BME members. I haven't seen anything that says that.
No, there isn't it. Thank you, Rob. They were the only points I wanted to make, as it were, as that prelude to going into the four particular headings.
Yes, thank you.
Starting with the second referral to the IOP, which is where I propose to move now, if I may.
Yes, of course.
The court doesn't want copious references to authority, and I'm not going to engage in them, but I would like to show the court one, what we say, crucial passage from the case of MacDonald versus the Ministry of Defence, which is in the authorities bundle at tab 19 and page 334. It's a lengthy judgment which the court is familiar. There was a significant amount of discussion of the then definition of a comparator, which was under the Sex Discrimination Act at the time, and in section 5 653, and the court has that. It's page 334, tab 19, McDonald versus Ministry of Defence. Yes. Thank you, Noel. Just if the court is looking at that, in the footnote, you'll see the third entry is section 5.3, which is the old provision in the Sex Discrimination Act 1975 on comparators. A comparison of the cases of persons under section 1.1 must be such that the relevant circumstances in the one case are the same or not materially different.
Yeah, so it's the same as section 23.
It's essentially the same as section 23,
yep.
Precisely. Thank you, Rob. And then on to paragraphs 63 to 65 in the Judgment of Lord Hope. There's a heading, 353 is the page reference. There's a heading, the comparator, above paragraph 63. And Lord Hope there makes reference to David Panic, now Lord Panic's book, Sex Discrimination Law 1985, in which David Panic suggested that the question of who was an appropriate comparator was not defined in the Sex Discrimination Act, was somewhat at large. And if I can then refer to paragraphs 64 and 65, and could I invite the court to read 64 and 65, please?
Yep.
And the key passage, we say, 64 by letter H, if relevant circumstances are to be the same or not materially different, all characteristics of the complainant which are relevant to the way his case was dealt with must be found also in the comparator. So the question then becomes, in relation to the referral to the second IOP, what were the characteristics of Mr. Karim which were relevant to the way his case was dealt with by the case examiner when his case was referred to the IOP for the second time? Now that question can only be answered by reference to the reasons that were given by the case examiner. And as I've already said, this is a decision to refer to the interim orders panel, as it then was, and then interim orders tribunal as it now is. The court's been to that. I invite the court to look at it again, if I may. It's in the GMC's bundle, and it's at pages 22 to 31. The prelude to it, I don't want to take up more time than is necessary on this, because of course it's the case, on my case, it's the case examiner's decision that's the crucial decision here, because that's the material complaint, the decision which is complained of. But you also have immediately before it the
which page are we on?
I'm sorry. Can I show the court what that is? So at pages 19 to 21, the court has.
This is of your one, your supplementary.
Sorry,
bundle.
yes, of the GMC supplementary bundle. Yes,
yeah.
I'm sorry. So this is, I mentioned this when I was describing Rule 4. So the investigation into Mr. Karim has been opened by a decision under Rule 4. It will continue until it's considered at the end of Rule 8 by a case examiner. But further information has come to the attention of the General Medical Council in the first paragraph there, under 29th of January 2015. whether the new information, under Rule 4 again, is adverse, which is how the GMC describes it. If it's not adverse, it isn't added to the investigation. If it is, it is. And the new information, as this tribunal is very well aware, was the Hollywood report and the conclusions in the Hollywood report. And you see that under case summary, because the Hollywood report had only been received in December after the previous decision in relation to referring to the IOP. And then we see under the heading potential adverse information. I'm on page 19. Yes. Whether Mr. Karim sought to interfere with Simon Robinson's submission of evidence. And what we see there is the local investigation being again a reference to the Hollywood report, highlighted a strong suggestion Mr. Karim sought to interfere with Dr. Robinson's submission of evidence to the GMC. This incident demonstrates significant probity concerns and should be investigated further by the GMC, therefore I deem it adverse. The next matter is the contact with Dr. Hayter. Now, my learned friend has said, oh, well, that turned out not to be anything very bad. At this stage, and this is the relevant stage for our purposes, the trust, which had reported this additional matter, is accused of further misconduct following the conclusion of the first investigation. First of these allegations is that Mr. Karim made contact with a colleague's patient's GP to request information and copy documentation. There appears no clinical need for this, and this is considered by the trust as a further example of Mr. Karim seeking to overstep his role and interfere on his colleague's behalf or in support of this colleague. As above, this demonstrates significant probity concerns which continue to appear not to be isolated. That's the point I was making earlier about the pattern of behaviour issue. I deem this information to be adverse and should be investigated further by the GMC. There's then another matter where Mr. Karim, after the previous interim orders panel hearing, had sent a video clip to the GMC showing another colleague in a poor light with the intention of prejudicing the colleague. That's said not ideal, but certainly isn't helping things in the urology department, but I would not deem it as adverse. So it's certainly not the case that the GMC here is tenaciously trying to find every possible allegation that it could pursue against Mr. Karim. There's then a series of other matters of incident dates. I'm not going to read all of those out from Frimley Health, but if the court would be good enough to look about halfway down above complaint ID 9057, decision, this is the AR. In my opinion, this is a system concern and communication from another clinician linked to Mr. Karim, as he was the named consultant, should be dealt with at local level, not adverse. The whole series of matters there said to be matters which should be dealt with at a local level, and they're not adverse, so they're not added to the decision. We then come to the bottom of this document, which is on page 21, where we see under the heading IOP, there is currently no order. Court's well aware of that. It says it light, but it must mean in light of the new information and the allegations above. Please now raise an IOP decision. So that's how it was referred to the case examiner for a decision on whether or not it should go.
So who's actually the author? I don't want to name, but what kind of person is this?
It's an assistant registrar.
Yeah, okay.
So we then get 20...
So I think I've misunderstood. Doesn't really matter, but the decision to refer to the IOP is an assistant registrar decision. It's not a case examiner decision.
Yes, yep. The assistant registrar has a power at any point to refer that. But the investigation can't be referred until the conclusion of the investigation under Rule 8. Sorry, yes, I'm being corrected, quite rightly. This is the adverse information decision. So as to whether or not this is added to the investigation. On the end, then, it just says there's no IOP order, so I'm going to refer it to the case examiner. The registrar could, under Rule 4, has the power to refer it straight to an IOP, him or herself. But that doesn't, it's not the practice that that's the case with any doctors. It usually goes to a case examiner for an independent look to decide whether to refer it to the IOP. And that's what happened here.
Is
Is that-
Well, hang on.
Question. No.
Okay,
Apparently not.
sorry, just so I can understand. So this is done by the assistant registrar, but the decision is to raise an IOP decision. That what you're telling me is that means, or at any rate meant here, that it will go to a case examiner
Yes.
for a decision, for a further decision.
Under whether to refer to the IOP.
Yes.
Not a decision whether or not to close the investigation, because the investigation's only just been opened in relation to these matters. They've only just been added to the investigation.
So is the assistant registrar a sort of filter that an allegation comes in, the assistant registrar can say, as with some of these items, this is not, this doesn't cross the threshold of being even plausibly something which impairs fitness to practice. End of that. But I find that this one and this one do, and I therefore refer them to a case examiner.
Yes, they could refer it to a case examiner, or they could just refer it to the investigation officer, which they will do anyway. So the investigation will be continuing after this in relation to these additional matters. But there's a further question about whether or not, in the light of the further matters, there should be an IOP order. And so that's the decision that's being raised at the end there, that it should go to a case examiner to consider whether it's appropriate to refer back to the IOP.
So the investigation will trundle along in the light of this, the decision or the recommendation that the adverse information should be investigated. But in the light of the content of that further information, the assistant registrar has thought that there needs to be a reconsideration as whether there needs to be any conditions to the effectively the practicing certificate of the doctrine in question.
Quite. That's precisely it, my lady, yes. And as we'll see when we come on to look at the case examiner's decision, one of the points that was made by the first IOP was that the investigation report at that stage was only a preliminary report and hadn't reached any conclusions about Mr. Karim. So the simple fact that the General Medical Council now had the conclusions of the Hollywood report, the December report in relation to Mr. Karim, was itself a piece of new information, as it were, which may in itself, who knows, have justified it. But as I said, that's not the way the decision is made, and that's what I was hoping to show the court now, beginning at page 22, which is the case examiner's decision itself. And the reason I'm emphasising this is because this complaint is about the second referral to the IOP. And so what were the characteristics of Mr. Karim which are relevant to the decision to refer him for the second time to the IOP? That's what we have at 22 to 31. You've seen this, so I'm going to take it very quickly. But you see at the top the decision that's been requested and the decision that's made.
You say we've seen this.
Oh, you haven't? I'm sorry.
When would we have seen
I
it?
thought you had. I thought you saw it this morning. I thought my own friend.
It's not marked up.
Oh, I've ticked it in my list of. Sorry,
Anyway.
my index.
Doesn't matter. No. I just was worried that I hadn't made a proper note.
Oh, well, I'm very sorry. But I'll still take it fairly quickly. I
Yes.
hope.
Okay. No, that's fine.
What the court will see is this. The date, first of all, the 2nd of February 2015. The decision is that it's clear that this is the decision which is complained about. In other words, in this particular, the decision to refer Dr. Karim to the interim orders panel for the second time. The question being asked under summary of concerns, I am asked to consider afresh whether Mr. Karim should be referred to an interim orders panel of the MPTS. The previous decision is then set out at length. I'm not going to read that out,
Okay.
but I did want to point to this matter. Paragraph 17 on the bottom of page 24. The IOP concluded there's insufficient information before it today that would warrant an interim order on the basis of patient safety. Consider there's no information to suggest that your Mr. Karim's clinical performance has posed a risk to patients. It also considers that a dysfunctional department is a managerial matter, and the allegations concerning you that have arisen from the report can be managed at a local level as per the recommendations. So it's been suggested that Mr. Laniardo, by the tribunal, Mr. Laniardo was given credit for it being for working in a dysfunctional department, but Mr. Karim wasn't. As we see, that's not correct. We then see that under the heading Further Information on page 25, reference to the investigation report, and it makes the point that the report considered by the IOP was the interim report and not a substantive one. And as we've seen, as we know, 3 of the 4 matters against Mr. Karim were found in the Hollywood report to be well-founded. That includes the additional allegation in relation to Mr. Robinson. There's then some matters set out in relation to Mr. Robinson on page 25, some of the evidence there, and the conclusions of the investigation report at the bottom of 26, highlighted, in bold. In my view, Mr. Karim's account of the meeting lacks credibility, as does his attempt to shift responsibility and so on. That's in relation to that, and the distinction drawn on the page 27. There's another paragraph, the 3rd paragraph down beginning, it is clear that Dr. Robinson was doing no more than complying with his duty as a doctor by providing a statement to the GMC when requested. Neither Mr. Motowala nor Mr. Laniado made any attempt to dissuade him from doing so, but Mr. Karim appears to have taken it upon himself, etc., to sow doubt in Mr. Robinson's mind. So then we see under that, after the quotation, summary of what the investigation report, the Hollywood report, found. That is to say that 3 of the 4 allegations were well-founded. That's the canteen meeting, the MDT letter matter, and Mr. Robinson. There's then stuff about financial irregularities. Then on the next page, page 28, following a meeting with Dr. Ho, medical director of the trust, Dr. Ho wrote to Mr. Karim to inform him that the disciplinary hearing would take place of the 3 above-mentioned allegations against him. And then I'm skipping down now to a paragraph, the 4th paragraph beginning, Dr. Ho's letter also explained that 2 further concerns about his conduct had come to light, which had been discussed with the HI director and NCAS, namely that there's the hater matter, number 1, and then the video clip, number 2, which, as we saw, was not considered adverse. And then the last paragraph on page 28, Dr. Ho concluded his letter by informing Mr. Karim he decided Mr. Karim should be excluded from the trust for 4 weeks. Series of grounds. I consider there's a risk your presence at work could hinder the ongoing process and the witness evidence, and necessary to protect members of staff. Then under the heading remit on page 29, we see the test that the case examiners has to apply, guidance on the interim orders panel, and so on. And then under the heading protecting patients at the bottom of 29, I note that Mr. Karim has been excluded from the trust in part because his alleged conduct is judged by the trust as raising patient safety concerns. While it could be said that his exclusion is sufficient to protect patients, I'm mindful Mr. Karim has a significant private practice. Private patients are not similarly protected by his exclusion. I conclude it's necessary in the public interest for Mr. Karim to be referred to the IOP. Then a discussion of the public interest. Page 30, 2nd paragraph from the bottom. I'm considering the matter afresh, as I've mentioned above. However, I consider it reasonable to be mindful of the reasons previously given by the IOP. Well, we've seen those set out at some length. The investigation, I'm now reading the last paragraph on page 30. The investigation into Mr. Karim's fitness to practice has progressed significantly since the IOP made its decision. Substantive investigation report is available. According to the trust, there appears to be a case for Mr. Karim to answer. Further, albeit similar allegations have also been made against Mr. Karim since the referral was originally made to the GMC, which are of particular concern, as they allege that Mr. Karim sought to unduly influence both the local investigation and that of the GMC. And then at the top of 31, well, can I just invite the court to read those 3 paragraphs rather than just read it all out?
Yeah.
So the emphasis is on the first paragraph, such serious allegations, plural. Next paragraph, given the nature of many of the allegations, and then on the next line, as a number of the allegations against him concern acts alleged against colleagues, both peers and junior colleagues.
Okay.
So we say it's entirely clear from that what the reasons for this decision were. And that's where you start, according to McDonald, that's where you start to identify what the relevant characteristics were of this complainant and then determine whether or not they're present in the comparator. And those characteristics, of course not all characteristics fact that they're left-handed or right-handed doesn't matter in a race case. But if those characteristics aren't present, then in relation to this decision at least, second referral to the IOP, Mr. Laniado wasn't an appropriate comparator. And we know that those matters, which collectively led to the case examiner's decision, weren't present in Mr. Laniado's case. And you've seen the Hollywood Report's conclusions in relation to him. I'm happy to show the court those again, but it may not be necessary to do so. In relation to Mr. Laniado, as we know, there was only one matter that was considered to merit any further investigation. No finding that they were well founded. My Lord, I'm looking at the clock nervously. I'm wondering if I've got until 4:30 perhaps. Or...
Well, I will catch my colleague's eye in a moment, but I think if it will shorten the time tomorrow, let's go on to 4:30, but no longer.
Yes, certainly. Can I just say this? The first part of my submissions on the substance are by far the longest. So once I've dealt with this matter, I hope the other two matters relating to Mr. Rao, we've already seen how closely related they are, will proceed relatively quickly.
Good.
And then I'll just have to deal with, well, I've dealt with the evidence really on the, the report.
Splendid.
And then I'll just have to deal with delay. And that will be, I'll be done by 10:35. No, I think I've been allocated until 12:30.
Well, we haven't. We've trusted.
That's not up to you.
We have trusted the two of you to liaise about time.
And that's what we've agreed. But I've started a little bit late, but I'm going to leave half an hour for this.
There is no encouragement from us to use up the whole of your time if you don't need to.
No, and I certainly won't if I don't need to.
Ms. Monaghan's done a lot of the heavy lifting. We've seen almost all the principal documents.
Yes.
Yeah.
Quite right. Yes. Thank you, my Lord. The point I wanted to move on to, not going back over everything you've seen in relation to the Hollywood report on Mr. Laniado, is to just put in this caveat, and I think it's a point the court already has. To call the allegations the canteen meeting allegation and the MDT letter allegation is a convenient shorthand. I've no doubt been guilty of using it myself. But there's a risk in doing that it leads one to assume that the allegations were the same in relation to canteen meeting and the MDT letter. And of course, as this court's well aware, they were not. In relation to the canteen meeting, it was Mr. Karim who raised the issue of Mr. Rao repaying the fees that Mr. Karim had lent him. And he did that because he suspected, Mr. Karim admitted this, he suspected that it was Mr. Rao who'd written the email critical of Mr. Motowala. So there's me trying to take it quickly, my lord. I think probably, do I need to go back to show you where that's set out? Or?
I think you do.
Yes, I'm sorry.
No. I'm the slowest in the class, but I think you do.
No, I don't want to leave my lord out there on a limb. Me too, please.
Yes.
Me three.
Right. Thank you. Well, if we look at the Hollywood report then, so we've got that in the GMC unagreed bundle, two reports in relation to Mr. Karim, but the first one you have seen is beginning at page 4 of the GMC's bundle.
Yes.
And the allegation, looking at page 6, whether Mr. Karim threatened, verbally abused and or intimidated Amath Rao at a meeting on the 16th of January 2014. Yes? Mm-hmm. Yes, and then if one looks at the evidence, that begins on page 7. And there's evidence there recorded. I'm going to take the court through all of this, but AR's Mr. Rao's evidence. JK is Jan Kalsi, Dr. Jan Kalsi. ML's, Mr. Laniardo's evidence, OK's evidence, that is to say, Mr. Karim, records Mr. Karim's evidence in his interview with the review panel on the 3rd of July 2014. Mr. Karim described his perception that Mr. Rao was trying to oust Mr. Motawala. Went on in the next paragraph, in his first interview with me on the 16th of September 2014, Mr. Karim confirmed that he had in mind the anonymous letter when he raised the issue of the course fees with Mr. Rao on the 16th of January 2014. He also confirmed that at that time he was certain that Mr. Rao had written the anonymous letter. Then the policies are set out, and then we come to finding. And this I'm sure the court has seen. Yes. It is clear that an inappropriate and inflammatory conversation was instigated by Mr. Karim, first point, during what purported to be a business meeting between the consultant neurologist on the 16th of January 2014, and that this could reasonably be perceived by Mr. Rao's victimisation, linked to Mr. Rao raising a concern about Mr. Motawala, which Mr. Karim accepted had been behind him raising the matter. By his own admission, well, that's what I've just said, sorry. By his own admission, OK's decision to raise this matter was linked to his belief that Mr. Rao tried to damage Mr. Motawala by writing the anonymous letter in November 2013. My view, it would be reasonable to conclude that Mr. Karim raised the matter of repaying the MSc fees paid 10 years ago for punitive purposes, linked to Mr. Rao raising a concern. This was contrary to the Trust's policies and expected standards of behaviour, and that Mr. Rao's complaint in this regard is well-founded.
So now you've taken to this, the summary of the concern, actually, the page before, so we now see what it was actually all about.
Yes.
Want to punish victim, suspected being an author of the anonymous letter, alleged misconduct, motivated by loyalty, long-standing colleague and business partner.
Yes. So, whatever conclusions Miss Hollywood had reached about Mr. Laniardo's involvement in this, it couldn't have been that he had instigated the meeting. He didn't lend the fees, and he didn't raise the issue of repaying the fees. He didn't have any view about who'd written the email criticising Mr. Motawala, and didn't feel that Mr. Motawala's position was undermined.
Or needed protecting as his position.
Or needed protecting, indeed, Maria. So just at that stage, at that level, one would say that although conveniently put under the heading canteen meeting, and to that extent you may say they're similar, the allegations were entirely different. Mr. Laniardo, equivalent, is at page 87, same bundle. I mean, the allegation was slightly different on page 88. Even the allegation itself was slightly different in it. Whether ML threatened and or intimidated Mr. Rao or allowed another senior consultant to do so without being challenged. So in itself, a certain difference. But in any event, the terms of reference then set out, as we've seen at 89. Evidence gathering, again, we see under this one, 5.1 on page 90. The evidence from Mr. Rao. Mr. Kelsey's evidence, I pause here as well, because we see that Mr. Kelsey's evidence, as Dr. Kelsey, I should say, as recorded here, on the third line down, second line, sorry, Dr. Kelsey supported Mr. Rao's interpretation of events at the meeting on the 16th of the 1st, 2014. That is, that Mr. Karim ambushed Mr. Rao by raising the issue of the course fees in the way that he did. Mr. Kelsey did not witness any comments of concern made by Mr. Laniardo, stated the evidence. There's Mr. Laniardo's evidence there. Also, in his interview with me, Mr. Laniardo, on the 22nd of October 2014, expressed his view that Mr. Karim had raised the matter of the course fees inappropriately in the meeting of the 16th, and that it was not a subject that was relevant to the matters they were there to discuss. ML said he was surprised Mr. Karim had brought it up. He discussed it later that day with Mr. Kelsey, saying that both he and Mr. Kelsey were speechless when Mr. Karim raised the issue of the course fees. He said he was equally surprised by Mr. Rao's response, which was to threaten to report Mr. Karim to the financial authorities for insider trading. There we are. And then we come to Mr. Karim's evidence. Again, Mr. Karim, I'm not going to read all of that out. You've seen some of that already. Mr. Karim doesn't say that Mr. Laniardo abused, intimidated, or threatened Mr. Rao. Findings on the next page, page 92. So I won't read out that first paragraph because you've seen that already in the report on Mr. Karim. And if you look down then below the policies on bullying and harassment, ML's evidence, perhaps those two paragraphs the court could just read to itself. ML's evidence suggests...
Yeah, we were taking to them.
You were taking to them.
No, we'll read them again.
I lost all confidence in the thought that the court's seen it, but yes, I thought the court had. And then if you skip the quotation, an examination of the messages, that is to say the email messages and so on, shows that Mr. Rao appears to have taken the above comment in isolation from the whole message thread for the purposes of creating an entry, etc. So then at the bottom of 92, I can find nothing in the evidence that Mr. Rao has produced which demonstrates any sense that he felt intimidated or bullied by Mr. Laniardo, whether before 16th of the 1st or on that day. On the contrary, the evidence suggests that communications between Mr. Rao and Mr. Laniardo were conducted in a mutually amicable spirit, notwithstanding that there was a difference in their respective views about the scope of practice. Mr. Rao appears to have gone to Mr. Laniardo for support and reassurance when he felt bullied by Mr. Karim on the 16th of January, and received it. In my view, the concern about Mr. Laniardo's conduct on that day, in both its constituent parts, is unfounded. That was the evidence.
What do you say about Ms. Hollywood's view, halfway down page 92, for Rao later to report Laniardo's comments as an attack by him is not credible?
Yes.
Ms. Monaghan says, well, the GMC regarded Rao as not credible, as it were, when it suited them, but they found him credible enough when it involved the claimant.
Well, it's two different things, because what Mr. Rao was considered credible about in Mr. Karim's case was in relation to all the matters for which there was corroborating evidence, or indeed that Mr. Karim accepted. That is to say that the question of repayment of the course fees was raised by Mr. Karim at a meeting designed to discuss other matters. And as we've seen, Mr. Karim did that in order to attempt to protect the position of Mr. Motawala, who he felt was threatened by the communication that had been written by Mr. Rao. So it comes back in two ways, I suppose. So the first answer is that. The second answer is the other corroborating evidence. I've spoken about Mr. Kelsey, Mr. Laniardo. Mr. Karim himself doesn't report anything about Mr. Laniardo, so there was no support, no corroboration for what Mr. Rao said about Mr. Laniardo, in contrast to what Mr. Rao said about Mr. Karim, which was supported by a number of witnesses, and indeed by Mr. Karim's own admission. And in any event, Mr. Rao wasn't regarded as a credible witness in Mr. Karim's case. That's what you saw in the RPT document. The legal advisor there was saying, I'm not sure this meets the test because Mr. Rao is not reliable. That's exactly the same as he was treated by Ms. Hollywood.
And so, must in fact be based on the Hollywood reports, because the legal advisor didn't have any other evidence about it.
No, I think by then there was further evidence, because this was in 2017. I think there was further evidence about Mr. Rao then. But in any event, the point remains that on both sides, either you can say Mr. Rao, the fact that Mr. Rao is found not to be credible in relation to one matter, in relation to Mr. Laniardo, doesn't destroy the credibility of all his evidence if it's corroborated by others and indeed substantially admitted. But in any event, quite apart from that, Mr. Laniardo and Mr. Karim were treated in the same way in relation to Mr. Rao's evidence by the GMC, because the GMC didn't seek a witness statement from Mr. Rao in relation to the canteen incident. and the GMC called instead the evidence of Dr. Kelsey and Dr. Laniardi on that matter. That's what we see the RPT legal assessor saying should be done. Obtain witness statements from them and then make a decision as to whether they're robust enough to proceed. So again, there's no difference how they were treated in that respect. And now, I am about to move on to a slightly different point. So,
Yeah, well, I think that probably makes a good time to break. Thank you very much. 10:30 tomorrow in the confident conviction we will not still be here at lunchtime tomorrow. Thank you for